Mr. Bursch, can I ask you this? I understand that you and your amici allege that the state engaged in some procedural moves at a certain point that were inequitable. But was the Attorney General's suit removable when it was filed and for the 30 days following the filing of the suit?
That's a very difficult question that the parties had trouble answering from the outset and probably continue to have trouble answering today. That's the kind of thing that we would encourage the Sixth Circuit to decide on remand, as you did in Beckler and also in Haro, sending back that hard question. All we're asking you to do is to declare that the presumption applies, that it hasn't been rebutted by the clearest command, and to reverse. I mean, it could be an opinion that's 160 pages less than the tariffs opinion last week.
Well, that's certainly a goal to aim for. I felt very left out in the tariffs case. Justice Sotomayor didn't write, and I didn't write opinions. But if
maybe we'll have a chance here.
If the governor's suit was removable, on what basis would we perhaps hold that the original Attorney General suit was not removable?
Yeah, so again, something you don't have to decide, but the argument we would make to the Sixth Circuit is that the district court didn't abuse her discretion, because as soon as the governor declared that the easement was terminated and then filed a lawsuit that asked for an immediate shutdown of the pipeline, I mean, keeping in mind this means depriving millions of people of fuel and propane in Michigan and Ohio and Canada, that everything shifted to that lawsuit and the affirmative lawsuit that we filed. And so the parties quickly agreed with the state trial court that the state trial court proceeding would just be stayed. And so that kind of sat on the shelf while the two federal claims went forward.
Well, I understand that, but what was the relief sought in the Attorney General's suit? It was an injunction, wasn't it, against continuing operation of the pipeline?
It could have been, but there were also a lot of other. There were state law claims in there. They didn't specifically invoke any federal questions. And there were lots of relief that could have been granted that would have stopped short of an injunction. So it wasn't clear to anyone that that was the type of case that the federal courts would have taken jurisdiction of in the first instance. And so what the district court relies on, this will be the abuse of discretion review that the Sixth Circuit would eventually give to this, is really five things. She says that the dispute is best heard in federal forum when you're involving literally the ability to cook and provide heat to millions of people. Second, that there was the gamesmanship that the AG engaged in. Third, you have this race to judgment between the state and federal courts, which federal courts don't want. You've got the national and international implications of now the treaty, which has now come into force by the time she rules on the governor's removal action. And then finally, unusually in this case, the state court hadn't done anything. Here we are 7 years later, and the state court has not issued any merit rulings, not any discovery rulings. So if the concern is that somehow maintaining the federal court's traditional equitable authority is going to open the barn door, that's not going to happen. This is kind of a unicorn case. And that's why you can see in the 11th and 5th Circuit, which have had this rule for more than 40 years and more than 35 years respectively, you're not seeing a flood of people coming in and succeeding on equitable tolling or equitable arguments.
Can I ask about that, Mr. Bursch?